So as far as land transactions is concerned, we have land transactions areas covered in first and second term. First and foremost, interest and dealings in land. So identification of interest in land and rights accounting therefrom. So basically you have to understand the interest in land, that according to the case of Katarika versus Katwiremo, we have what we call legal interest as well as equitable interest. So basically when we talk about a legal interest, we mean interests that have been registered in land. So basically that's what we call a legal interest. But also also have equitable interests. And when we talk about equitable interest, the ones which have not been registered. So the case of Katariko versus Katwiremu basically gives us what we call interest in land, and also what we call both legal and equitable interest. That the legal interests are the ones which have been registered, whereas equitable interests are the ones which are not registered. But we have the case of Katariko versus Katwiremu, which basically explain those interests. So when we talk about interest in land, first and foremost, we can have what we call matrimonial property, because once we have matrimonial property under Section 29 of the under Section 39 of the Land Act, that basically means that all parties, or the husband and wife, both have interest in that land. Then also we can have, of course, joint tenants who also have interest in that land under Section 56 of the RTA. When we talk about joint tenants, we mean people who own land who own land, and basically these joint tenants have what we call the doctrine of survivorship, which basically means that when one joint tenant dies, then the land is left to the other tenant. So here we have the basically what we call the unity of title, unit of time, as well as unit of possession. But you have to understand the doctrine of survivorship when we are dealing with joint tenants under Section 56 of the RTA. Then also we have what we call tenants in common, and basically when we talk about tenants in common, it means that the parties have rights in equal shares. It could be 50-50 of that land. Also you have to understand bona fide and lawful occupant, and under Section 29, lawful occupants, these are people who have settled on the land with the consent of the registered proprietor. And also bona fide occupants, they are people who have been settled on that land either by the government, or maybe by any other local authority. So to understand that relationship, we have the case of Catherine Rwamhanda and also George Catherine Tirirwe versus George Rwamhanda, which basically defined lawful and bona fide occupant. Then from there we also have classification of interest in land, legal and equitable interests. And I've said the legal interest is the one which is registered, whereas an equitable interest it's not. Then we also have protection of interests in land. So protection of interest in land can be done by lodging a caveat, because once you have an equitable interest, remember under Section 123 of the RTA, all persons who have interest in land have rights to lodge caveats in land. So this includes both legal and equitable interest. So an equitable interest can arise, for example, where you have sold me land and I have only paid part. That basically means I have an equitable interest in that land. So a sales agreement just gives you an equitable interest to land. Then also we are looking at certificate of title evidencing interest in land. So under Section 59 of the RTA, a certificate of title is conclusive evidence of ownership. And then when you look at certificate of title is a conclusive evidence of ownership, which basically means that it can only be impeached on instances of fraud. For you to impeach a certificate of title, then you can do what? You can only prove fraud for you to impeach that certificate of title under Section 59 of the RTA. So we're also looking at certificates of title evidencing interest in land under Section 59 is conclusive evidence of ownership. But you also have to understand different types of titles. One, we have what we call a duplicate certificate of title, which you always have at your home. We also have what we call a special certificate of title, where the registrar orders where the court orders the registrar to issue what we call a special certificate of title, and we also have a substitute certificate of title, which is also issued in the case the duplicate is missing. Then we also looked at acquisition of certificate of customary ownership and procedure bodies and documents, and basically this one arises under section I think 4, 5 and 6 of the Land Act, where you can apply for what we call certificate of customary ownership. So for you to apply for certificate of customary ownership, one, you have to apply to the area land committee, and then after applying to the area land committee, they issue a notice, and in case there's anyone who's aggrieved, we have hearings and mediation, and then the area committee makes a report, and then they submit this report to the district land board, which can either confirm, vary the decision of the committee. So after that, then they can grant what we call a certificate of customary ownership, which is conclusive evidence of owning that customary interest. Then conversion of customary tenure to freehold, also looked under the Land Act, that you can apply to convert customary ownership to freehold. If you have a certificate of customary ownership, you just have to fill the forms under regulations, and then you can they can have that land converted to freehold, because I've said that certificate of title customary certificate of title is conclusive evidence of ownership. So tenants of customary tenure, individual, family, and communal. So customary ownership can be owned by individuals, can be owned by families, or by communal system, or by what we call the community. Then interpreting customary tenure, interpreting entries on certificate of title, meaning and legal implications. So basically, when you look at the certificate of title, one, we have the cover page, which has the description of the cover page, which has the block district in which that land is. Then from that, we have part 1, which gives you the tenure under which that land is being owned. We also have part 2. Part 2 basically gives the ownership of the land. Then from there we have the deed plan. The deed plan gives you the boundaries of the land. Then we always have the conditions page. In case there are mortgages or caveats, they can be registered on the conditions page. Then land tenure systems, we looked at different land tenure systems to include the customary ownership, which is owned by the community or maybe inherited in family. We also have what we call leasehold, the ones which can be owned by non-nationals but also by Ugandans. We also have Mairo, the one which was introduced by the 1900 Uganda Agreement, and we have freehold, which can only be owned by Ugandan citizens. Then conversion of tenures. For example, you can convert a leasehold to freehold if you're a Ugandan citizen, and you must have, of course, there must be a sales agreement, because you must have both that land. Then you can proceed and you have that interest converted to freehold once you fill the forms provided for by the land regulations. Then you also have deeding in land and due diligence. So basically, you deed in land and make proper due diligence. First and foremost, by making a search on the title. Secondly, by doing a physical search. Thirdly, you have to also do surveys on this land, and also get the necessary approvals from NEMA and other like the district planning committee. Remember, we have cases, for example, John Matovu versus John Matovu, where the case is saying that land is not like vegetables where you buy from unknown vendors. We also have the case of David Sejaka versus David versus Labeka Namsoke, where the council did not conduct proper due diligence, and of course they said you couldn't rely on the doctrine of bona fide purchaser for value without notice. Then also looked at all restrictions dealing in land. For example, citizenship. A non-citizen cannot own freehold in Uganda. They can only own leasehold. We have the minority. Minors can only own land. But once there is the land is registered in the names of the minor, that means you cannot transact with that on that land without what we call a guardianship order. So you have to proceed by notice of motion and also an affidavit in support, and apply for what we call guardianship order. Then also have family and matrimonial land. family and matrimonial land. Basically, under section 39, family land is where the home derives its sustenance, whereas matrimonial land is where the husband and wife are living together as husbands and wives. Remember, under the case of Alice Accord versus Global Capital Safe, the court stated that any transactions where there is no spousal consent, it's always null and void. Then when talk about insanity, remember that people who are insane can contract in times when they are able to understand what they are doing, but if they are not in a position to understand, then they cannot be in position to enter into any contracts. Dealing in land, structure, contract of sale of land, and other contracts. So we basically looked at a land sales agreement which we drafted, and then also had transfer forms. Basically, how do you transfer land? Where we had the land sales agreement, transfer forms, registration of the transfer forms, and also payment of stamp duty, as well as the registration fees. Then breach of contract of sale of land and remedies available for aggrieved party, specific performance, suit for price, damages, vesting order, and caveats. So basically here we looked at one rescission, that if I have bought land from you and I have failed to pay and you have another buyer, you can rescind the contract. But also we also have specific performance where you can show that the other party does the part that you agreed in the contract. Then also we looked at vesting orders, and said vesting orders arise under section 151 of the RTA. And if you have bought land, you have paid the purchase price, and then the buyer can't be found, either dead or can't be found, and you are in possession, you can proceed, and the registrar can vest that land into your names. And have the case of Ivan Mutakura, basically, which gave those grounds we want to include that you have evidence of payment of purchase price, you are in possession of the land, and also the seller can't be found, or maybe is outside of the country. So we also looked at caveats. Caveats can be one against vesting orders, or maybe caveats against adverse possession. So we said the adverse possession arises under section 77 of the RTA, and this one arises where a person has been on land and challenged for 12 years. So if the person has been on land and challenged for 12 years, then you can proceed and apply for what we call adverse possession. Land ownership by incorporation of trusts. So if you want to give land to a church, you can incorporate a trust. So once you have incorporated a trust, then we need a trust deed, and then you can continuously sign what we call transfer forms for us to have that land able pass to the church. So remember the case of Knight versus Knight, which basically explained or discussed what the contents of a valid trust. We must have certain of objectives, we must have certain of beneficiaries, and also the purpose of the trust must be very clear, or that what we call intention. That's basically how you would do a trust. And after incorporating a trust, you apply for the line ministry, you attach the trust constitution. Then after attaching the trust documents, then the ministry can accept you to incorporate a trust. So land ownership by incorporated trusts, we have looked at that. Caveats as encumbrances on land, caveat of interest, how to lodge caveats, lapse of caveats, and removal of caveats. So section 120 of the RTA basically states that any person can lodge a caveat on land. But if you have lodged a caveat, remember a caveat must be supported by an affidavit, and if you have lodged a caveat, you must put your grounds for lodging that caveat, and also the places where notices can be served. So once you have done that, then you would have lodged the caveat. So we have a lot of caveats in land. One, caveats for spousal consent, caveats for beneficiaries, caveats against vesting orders, caveats against adverse possession, among others. So transfer and transmission of interest in land. Transfer arises where there is a sale, whereas transmission arises where there is a death, and you must have letters of administration, or what we call letters of probate. So you have to understand the difference between transfer and transmission of interest in land. Agency in land transactions the power of attorney, execution, attestation, registration, interpretation, and enforcement. So basically, the powers of attorney, I think under section 130, must be properly executed and attested to. And have the case, of course, we have the case of Frederick Zabwe versus Frederick Zabwe, which basically discussed how powers of attorney must be created and attested to. But remember, powers of attorney, you can give power to the other person to do anything that you are supposed to do. Then we also have co-ownership of land, where we have joint tenancy and tenancy in common. And we say that joint tenancy is under section 56 of the RTA, whereby people are owning land, but there is a unit of title, unit of possession, and also unit of time. So it means if one tenant dies, then there's a doctrine of survivorship, and the other person takes over land. We also looked at basically what we call tenants in common, and tenants in common are the ones whereby we have these ones, their percentage is known, so it could be like 50-50. Then we looked at identification, features, rights accruing therefrom, dealings in this kind of land. Then dealings in land and escrow considerations generally. So when you're dealing in land, of course, you must do proper due diligence under regulations 2, subregulations 2 of the advocates for jurisdictions. The lawyers must do proper due diligence. Of course, we have the case of John Aus Matovu, where the court is saying that land is not vegetables, where you buy from unknown vendors. Also have the case of David Sejak and Arima versus Sarabek and Musoke, where the lawyer failed to do proper due diligence, and fraud was imputed to the person who bought the land. So you must do proper due diligence. Don't overcharge clients. Avoid conflict of interest. And don't sign champati agreements where there is litigation. Then have leases, tenancies, and licenses. Basically, this was week 2, where we looked at leases, and we say that the leases arises, for example, where you have a non-citizen, because non-citizens can only own land under what we call a leasehold. So leasehold is created by contract, but also it's created by law. So leasehold is whereby you are going to be having exclusive possession under the case in Mont versus that case of Mont, which basically Montford, which basically discusses exclusive possession in leasehold. That once you have leasehold, then it's always exclusive possession. So a sublease arises if, for example, you have a lease of 99 years, then you can sublease to another person for 40 years. So basically, a sublease is where a sublessee now leases the land to another person, but of course with the consent of the owner of the land. Then meaning, creation of leases, types, terms, and conditions of a lease, and termination. So we looked at, of course, how a lease can be created, and a lease can either be created by creation of law, or it can be created by a lease agreement, or what we call contract. Types of leases, we can have, of course, subleases. We can have a fixed lease. Then terms and conditions of the lease and termination. We looked at terms and conditions of the lease to include payment of premium. You must abide by the user according to what you basically agreed in the contract. Then termination of the lease can be by surrender, where the lessee surrenders the lease to the lessor. Then we also have a merger. Merger basically arises where the owner of the land buys the lease interest. So as the lessee buys out the lessor's interest. So basically, we have what we call reversionary interest. Reversionary interest, it means that once the expiry of the agreed time, the lease goes back to the what? To the lessor. But now, if you buy out the lessor's interest, that means we have a merger. Then lease can also be terminated by notice, also by forfeiture once there is termination of a breach of the contract. But also, lease can be terminated by what we call issuing a notice to the person. Then also looked at due diligence to make, which is always not a different one, looking at the registrar to identify the details of the owner of that lease, visiting the land, obtaining necessary approvals, and also opening the boundaries. Then transactions dealings in land under the lease tenure. So all transactions or dealing in land must be in accordance with the lease agreement. Remember, you cannot do anything which you didn't agree in the lease agreement, because that will be termination of the lease. So if they have given you the land for farming, you can only use farming, and you can only change the user by what we call a variation deed, which basically changes the user. Certificate of title to land held under lease tenure, identification of tenure, interpretation of entries, meaning, and legal implications. So basically, when you are having a certificate of leasehold title, you want to look at the sales agreement, and you look at what is the user of the lease. You look also at the time frame of the lease, how many years is the lease left to expire, and also who is the lessor. Is it the district land board, is it the Uganda Land Commission, or maybe it's a company or an individual. Then look at structuring a lease deed. Basically, lease agreements must have a user provision, time frame, payment of premium, consideration, warranties of the buyer, and also warranties of the seller. Then also we looked at a deed of surrender. Deed of surrender arises where the lessee is surrendering the lease to the lessor. You draft what we call deed of surrender. Variation deed, it comes out when you are changing the user of the lease. So if you have been given use for farming and you want to go for industrialization, then you can sign what we call a variation deed. Creation of a legal lease. A legal lease can be created in instances where, for example, you find that you have been declared a non-national of Uganda. That means all the land you have automatically are converted into leases. So where a person is not is declared not to be Ugandan citizen, all the land automatically converts to leasehold. Then also look at remedies of breach of a lease contract, damages, and re-entry. So once there is forfeiture once there is forfeiture, that means there is a breach of the lease agreements. The owner of the land can forfeit and continue to re-enter the land under what we called notice of re-entry. Then we also looked at relief against forfeiture, which is also by notice of motion supported by an affidavit. If you can prove that, for example, you have not paid rent and now you are in position to pay the rent, then you can apply for what we call relief from forfeiture from court. Conversion of lease into freehold tenure system. You can convert lease. Of course, we have, I think, Section 28 of the Land Act, which basically gives us the procedure of how you can convert leasehold to freehold, but also the regulations give us forms that are supposed to be filled. We also looked at tenancies, different types of tenants. One, commercial periodical tenants, and these ones are the ones who pay rent in a monthly period of time. We also looked at tenancy by sufferance. A tenancy by sufferance arises where your rent has expired, but you are still in that land, so you become a tenant by sufferance. We also looked at gracious tenants, the one who have been on that land with the consent of the landlord. Also we looked at licensees. Licensees could include if you have rented a shop and there are kiosks or like mobile money, those ones become licensees. Fiscal considerations, of course, doing proper due diligence, not overcharging clients, avoiding conflict of interest, and don't sign champati agreements where there is litigation. We also looked at access to roads and easements under Section, I think, 6 of the Roads Act, that if someone has broked your land, you can proceed and apply by letter supported by the state declaration to the minister. You can apply by letter supported by state declaration to the minister, and the minister can, of course, negotiate, and then you compensate, and then you'll be able to get access to land. Then looked at easements. Basically, we have a lot of easements. Could be right of way, right access to water, right access to electricity. All those ones are easements, and creation easements are either created by law or by contract, and they can be terminated on expiration of time. They can be terminated on agreement, and also they can be terminated once, for example, there is some other land. You can terminate easements. So easements in common law as distinguished from access to roads. So basically, easements are the ones which give you to access. It could be accessing water. It could be accessing to a public way. But access to a road happens where there was a road and has now been blocked, or maybe you want to access a road and you have no way to do that. So you would apply to the ministry, and the only way you can do that is to by letter of the ministry supported by statutory declaration. We also looked at under compulsory acquisition of land, and compulsory acquisition of land is under Article 26. Remember Article 26 1, any person has powers to hold land either alone or in association with others, but under Article 26 2, government can compulsory acquire land if it's in public interest and there is prior, fair and adequate compensation. But also we have the case of course, Sumani Irumba versus UNRA and Anthony General, whereby the court stated that you can only the government because they challenged the Land Acquisition Act, which was stating that the government was allowed to acquire land before it proceeds to compensate. But what the court stated is this was contravening Article 26 of the Constitution, because it was against the Constitution. It was against the right to fair, free and adequate compensation. Then have land registry practice and the power of the Commissioner for Land Registration, Register of Titles, the procedure for suing the Commissioner for Land and Registration and removal of encumbrances and instruments used in the different land transactions and ESCO considerations. So basically, when you look at the Commissioner for Lands, the Commissioner for Lands have powers to rectify errors which are on the title. So once there are errors of misdescription of the title, the Commissioner for Lands have powers to rectify these issues. So the procedure for suing the Commissioner for Lands, so you remember you can sue the Commissioner for Lands. We have the case of Sarah Kurata, also versus Commissioner for Lands. So you can sue Commissioner for Lands once he failed to do something that's supposed to do under the law, or maybe he was negligent in doing his power. So you can bring a suit against the Commissioner for Lands. So registration and removal of encumbrances instruments in different land transactions. So you can remove encumbrances. For example, you can remove caveats once you have served a notice to the person who lodged that caveat, or maybe at the expiration of 60 days, if they have no plaint which has been lodged, the registrar has powers to remove that caveat. Instances when the Commission of Land Registration of Titles can be sued and the procedure applicable. So we say that the Commission of Lands can be sued where he has failed to do act a thing under the law, or maybe where he negligently failed to do his powers under the act. Also look at fraud, irregularity and error in dealing in land and the effect thereof. So under Section 59, a certificate of title can only be impeached in instances of fraud. So basically, where there is fraud or maybe an illegality, then the certificate of title can be impeached. And remember, fraud must be strictly pleaded and proved. So basically, the case of Makura International Limited versus Cardinal Subuga, the court was effective that once fraud is brought to the attention of court, then it overrides all other pleadings of court. But you have to understand that fraud is only one of those grounds that can impeach a certificate of title. So basically, what you have to do is that once there is fraud, you have to bring a plaint, but you must properly plead how did the defendant participate in doing the fraud, or maybe how did he do the fraud. So if you have sued also the Commissioner General for Lands, you must give how did he participate in that fraud, either by failing to do an act or by negligently doing an act. Then we are looking at special powers of the Commissioner for Lands Registration under Section 91 of the Land Act as amended. So basically here we are saying that Section 91 of the Land Act gives powers of the registrar to rectify errors in the title, to include misdescription errors, to include where it's given too many hectares, but he cannot only deal with fraud. Fraud can only be dealt with by court, but all those errors on the titles can be rectified by the Commissioner General of Land. Then fraud in dealing in land and the effect thereof. When we talk about fraud, we're saying that fraud is doing an act with the intention to take away with something which belongs to another one, or maybe when you do an act with the intention of stealing someone's land, it's called fraud. And fraud can take different forms, of course. It could be forging documents, it could be not doing proper due diligence. All that one can constitute fraud. Types of fraud, of course, we have direct fraud, we have indirect fraud, constructive fraud. All those ones are fraud. Features of fraud, of course, fraud must be specifically pleaded and proved, and it's an illegal act or unlawful act to part away with someone that does not belong to you. Pleading fraud, it must be specifically pleaded and proved. Burden and standard of proof. The burden in civil matters is on that person who wants court to believe an act, and the balance of probabilities, and the standard is always on the balance of probabilities. Then remedies are recovery of land acquired through fraud, consequential orders, procedure, forum, and pleadings. So basically, we also looked at consequential orders. Consequential orders can arise, for example, where you have a judgment from the magistrates courts. It could be that the magistrates courts have declared that the land was acquired fraudulently. You can proceed under consequential order, and then you apply to the High Court, and the High Court orders the registrar to vest that land, to change that title into your names. And I think this one is always by a notice of motion supported by an affidavit, whereby you ask for consequential orders, and the consequential order arises where you have a judgment of the magistrates courts, and you want to ask court to vest that land into your names. I also looked at remedies, consequential orders, procedure, forum, and pleadings. We have looked at that. Damages against the government, a relevant procedure. Basically, where you have damages against the government, we say that you use a letter to the Attorney General, and you ask for this for the government to be compensated to you in case you suffer damages because of the negligence of the Commissioner of Lands. Damages where recovery of land is not possible. So where recovery of the land is not possible, you can seek for compensation under the Act. Illegality and error in dealings in land and the effect thereof, powers of the registry of titles, and procedure in cases of land affected by illegality or error. So where the land has error, you have to go for rectification of that title. So basically the procedure is you apply to the registrar calls a public hearing, and he hears all those hearings, and then after that he can be in position to rectify that title. But where there is an illegality like fraud, remember you have to proceed by plaint, because the registrar has no powers to hear instances of fraud. Defenses suits for recovery of land based on fraud, the defense of bona fide purchase of value, and others. So basically you can have the defense of bona fide purchase of value, but also you can have a defense of time limitation. But basically bona fide purchase of value arises where, for example, you have you paid valuable consideration, you bought the land in good faith, and fraud cannot be imputed on you. So if you have all those things, you bought land in good faith, you paid valuable consideration, you can proceed under the defense of bona fide purchaser for value without notice. But remember, in the case of David Sejaka versus Rabeka Namusoke, where the lawyer had found an old woman on the land but did not do proper due diligence, the court said that he could not rely on the defense of bona fide purchaser for value without notice, because there was constructive fraud and the council had failed to do what we call proper due diligence. Then here we are looking also at ISCO considerations. ISCO considerations include not invading in Champati agreements. Of course, Champati agreements we are discussing the case of Frederick Mwema versus Shell Uganda Limited, where a lawyer is not supposed to deal into or to go into agreements that entitles you to share the fruits of the judgment, because you are only entitled to costs but not the judgment. So where there is a Champati agreement, that becomes an invalid agreement and cannot be enforced by law. Then also start doing proper due diligence, where we have that in the case of John Ausi, that land is not vegetables which you buy from unknown vendors. We also looked on condominium properties, meaning of condominium. Condominium is whereby a person buys land and then builds houses and divides them into condominium, and each condominium has its unit title. So you find that each condominium has a unit title, and then you can be able to get a title on each unit. So we have a mother title, but then you have to develop this land, and the register of titles you can apply, and it gives you different unit titles. Creation of condominium property. These ones can be created under the Condominiums Act, and once you have both land and proceed to subdivide it, then you can apply to registrar, who is going to give you unit titles for each unit of that land. So the other thing is about silent features of condominium property. We have what we call unit area. That means if you have, it could be an apartment, unit factor, common areas, community of use, and easement. So basically, condominium will have easements. Easements could be like the pathways in the building. It could be like stairs. Then also we can have condominium corporation. Basically, condominium corporation helps in the management of the property, because remember, you don't have any landlord, you are the owners. Then also have common usage areas like pools, like gardens, like maybe it could be having a swimming pool, like gardens, like garbage areas. Then you also have a corporation. A corporation plays the part of managing the condominiums, first and foremost, scoring meeting, resolving issues, putting a payment to be paid, and also making sure that in case there are any new members, they also recruit them in the management of the property. Then tenancy agreements for condominium. You can have a tenancy agreement for condominium whereby you have tenants. Then post-sale obligations of the property developer. You must make sure that you have given titles to the units, and also there is a corporation, because if there is no corporation, the property can be brought to waste. Then physical planning and condominium development. Remember, under the Physical Planning Act, all areas in Uganda we are declared as physical planning areas, which basically means that for any development to make on land, you must first seek consent from the district planning committee. So you cannot make any development if you have not gotten consent from the district planning committee and other approvals, for example from NEMA. Then also look at the law on condominium property, meaning of condominium. I have looked at that, creation of condominium. I have looked at that, and physical planning and condominium development. So the last topic here we are dealing with mortgages. Mortgages are governed by the Mortgage Act. Meaning of a mortgage. Remember that mortgage is only under Section 3. It's a security for the payment of the debt, but must not act as a transfer. So we looked at what we call legal mortgages as well as third-party mortgages. So basically, legal mortgage is the one where you find that the person pledges his land for the payment of the loan. And third-party mortgages, if you are find that you are using a property of a third person, or maybe the company is using your property, then that becomes a third-party mortgage. Features, nature, contract, interest in land, security only, among others. So what you have to understand is under Section 3 is that a mortgage is only supposed to work as a security, but not as a transfer of the land. So any transaction that is a transfer is null and void. Then also looked at what we call a mortgagor and a mortgagee. So basically, when you look at Section 1 of the definition section, a mortgagee is defined as a bank, whereas the mortgagor is the person who takes the loan and gives the security. So you have to understand that difference, because people always confuse them. Mortgagor is the client, whereas mortgagee is the bank. Then we looked at first and foremost, mortgage distinguished from a pledge and a chattel security. So a chattel security is when basically you give something which is movable, like a car, because a car is not a mortgage. You are just giving a chattel security, something which is movable. Then types of mortgages: legal, equitable, and informal mortgage. Legal mortgage are the ones which have been registered under Section 54 of the RTA, of course. Then have equitable mortgage, where a person just deposits a sales agreement and then they have not been registered, which can also include informal mortgages, because the section defines informal mortgages also include equitable mortgages. So we look at subsequent or second mortgages. So subsequent or second mortgages arises in situations, for example, where you get a loan from Stanbic and you also proceed to go to get the loan from DFCU under the same security. So the loan from the second bank becomes subsequent or second mortgage. Then third-party mortgages arises between where you find that you are pledging land, but it's not yours, it's for a third party. So it could be a company where you're giving land to the company that they pledge it, but it's not company land. So that becomes a third-party mortgage. The power of attorney, we can also create mortgages through powers of attorney, like what was in Frederick Zimbabwe versus Orient Bank, because the person had given Frederick Zimbabwe powers of attorney to mortgage that property. So a mortgage can also be created through one third party and also powers of attorney. Then also here we have execution, attestation, registration, and interpretation. I think under section 130 of the RTA, the mortgage must be properly attested to and registered. So once there is no attestation, then the mortgage, the powers of attorney cannot stand. Precaution duties of intending mortgager and intending mortgage. The precaution is that you must conduct proper due diligence by looking at the cash flow, because at the end of the day, the mortgage only works as security but not as a transfer. So you shouldn't give money to a person merely because he has land in Mnyonyo worth 1 billion, yet you know that he cannot be in position to pay that money. That means you'll be wanting to take away the mortgage rather than securing the loan. So pre-contractual duties of intending mortgager and intending mortgagee, duties of a mortgager to a mortgage and a mortgagee to a mortgage. So a mortgager to a mortgagee, basically you are supposed to pay the loan as we agreed. You are supposed to hand over the security to the mortgagee. Whereas the mortgagee, upon free payment of the loan, you must have a discharge of the mortgage, as well as what we call discharge of the mortgage, as well as the release of the mortgage. That once I have cleared payment, the mortgage must be discharged or released. Then due diligence, of course, you must have to look at the financial capacity of the person. If it's a company, is there board resolution? What is its cash flow? What is its source of income? That's basically the due diligence you have to make. If it's matrimonial property, do you have spousal consent? If it's joint property, have you gotten? Do you have consent from all the joint owners, among others? Then also looked at creation and validity of a mortgage, mortgage deed, execution, attestation, and registration of the legal mortgage. So once you have created a mortgage, you must proceed to register it under section 54 of the RTA, because it's one of the instruments that transfers interests in land. Then enforcement of a mortgage, remedies for the mortgage against the mortgager in default, and the procedure for enforcing each remedy. So basically here we have a lot of remedies available for the mortgagee. One to include appointing a receiver. Secondly, sale. We also looked at entering possession, leasing that land, among others. But when you look at the Mortgage Act, it gives you different remedies that are available for what? For a mortgagee. Once there is a default, one, he can sell that land, he can lease it, he can enter possession, he can also appoint a receiver. Then we looked at remedies of parties agreed by terms and conditions of a mortgagee, review of the mortgage, which is always by notice of motion supported by an affidavit, I think under section 32 of the Mortgage Act, which basically means that any of the parties can apply to court to have the mortgage reviewed. Or stoppage of sale and conditions attached thereto. We looked at also challenging the sale of the mortgage, which is by plaint, once the procedure has not also been properly followed. We looked at creation of further charges, meaning condition, procedure, necessary legal documents, and fees payable. So basically, when we talk about a further charge or maybe a right to tax, it means that if you have created the mortgage, you can also include what we call a right to tax. So it means that if you also advance that money to the bank, then it will have priority over the subsequent mortgages. Then also have variation, discharge, transfer of mortgage, procedure, legal documents, and fees payable. So we looked at the variation of the mortgage, or what we call memorandum of variation, which basically arises where you want to vary the terms of the mortgage deed. So in case you want to vary an interest or maybe the payment terms, you can proceed under what we call a variation deed. So discharge of the mortgage arises where the person has completed payment of the all terms, all the money owed under the mortgage. Then if the bank has to discharge your mortgage. Transfer of mortgage happens when you fail to pay. Then they can transfer the mortgage to the person who has bought the land. Then procedure, legal documents and fees payable. So once you have failed to pay the loan and they have proceeded to sell, then they can transfer that land to another person. Mortgages and contract of guarantee. So basically we look at contract of guarantee, which are covered by the Contracts Act, and the contract of guarantee is whereby you guarantee to pay for someone in case he fails to pay. So basically that you become a guarantor. But these ones are covered under what we call the Contracts Act, which basically provides for this relationship. Duties and liability of the guarantee and rights of the guarantor. So basically once you have guaranteed to pay, that means once the person fails to pay, then the duty to pay goes back to you. But you can be indemnified. Indemnified by the other person, or maybe you have subrogation rights, which makes you that once you have paid, then the bank can give you the collateral security, and also you have rights to go and ask your money from the other person. But basically those are the rights which are always available to the guarantor under the contract of guarantee. It include indemnity. Indemnity basically means that the other person has to pay you, or maybe subrogation, where you claim from a third party, you pay the bank and then claim from the person who you had guaranteed. Rights, securities, priority of charges, mortgages, etc. And discharge of the contract of the guarantee. This arises where you have paid. If you have paid the bank, then the contract of guarantee is discharged. Escrow considerations, of course, one, here there must be proper communication among the parties. Then secondly, the bank also must discharge the contract of guarantee once you have paid, and also the legal counsel involved should not overcharge clients and should advise by doing proper due diligence. Then a mortgage distinguished from money lending transaction. Remember that a mortgage distinguished from a money lending transaction. So we also have money lending transactions. Remember that for you to operate a money lending company, it must be licensed. It must be a company incorporated under the law with a money lending license. That's when you are allowed to have what we call a money lending business. So the law governing money lenders, we have the Tier 4 microfinance, the money lending transactions, distinguished form of mortgage, etc. Security interest in movable properties. We also looked at security interest in movable properties. For example, where you want to pledge your car to get a loan from the bank, then basically how do we go about that? So it means that if you want to pledge your car to get the loan from the bank, then under the Security for Movable Properties Act, the bank can also proceed to register that charge or that security on that car under what we call the Security for Interest in Movable Properties Act. So basically those are the highlights of land transactions. I believe I have fed you with the sketch details, and if you have understood, you can just go and add in more frames in your workshops. I believe orals are going to be good for us, and I really wish you success in your oral exams. But what you have to understand, you are not the first one to do orals, and neither are you the last to do the orals. So don't let anyone scare you. Just enter that room, and please don't be scared by anyone. Just enter there with the mentality that you have the capacity and confidence to answer any question that's going to be put before you. But in case you need mentorship program, we run a mentorship program covering all campuses: Mbale, Kampala, Lira, Mbarara, and Kampala. It's always an online workshop. We discuss for orals and make preparation for orals, go back to all the workshops and remind you the principles. Then after that, we handle questions and answers, and basically giving you the approaches, which questions were asked, what were our mistakes, and how basically can we avoid those mistakes so as you can pass the oral exam. So please, thank you for listening to this video. Please like, subscribe, comment, and share, and always come back for further updates. I really wish you a blessed day ahead.